first, but we'll go ahead and start and proceed. So let's do roll call. First of all, if you put all your phones on mute, if you would please, and identify yourself with name first when we respond to any particular votes or any comments or anything of that nature. Name first, and then proceed with the comments. So we will proceed with the roll call. Dolores Campion, present. Mr. Bittner?
Present.
Mr. Anderson?
Present.
Mr. Kiley?
Present.
Mr. Morris is on his way. Mr. Yelovich is not here, absent. Mr. Stanley? Here. Mr. Halsey? All right, we have a quorum. So next item on the list is item number C, training for board members. Item number 1, Open Meeting Acts.
Test, test. Oh, wow, hot mic. Hot mic. Thank you, Chairman. Doug Jennings, Assistant General Counsel for the Department. I'm just going to stand over here rather than crane my neck from the table. Just wanted to run you through your annual training. On your annual advisory board training will be covering the Open Meetings Act, the Public Information Act, and the Administrative Procedure Act. I'll try to keep it brief for you. If at any point you have a question, just feel free to interject, and I'll be happy to answer. Like I said, Open Meetings Act, the Administrative Procedure Act, and the Public Information Act, what we'll be discussing today. And the majority of this training will involve the Open Meetings Act. The Open Meetings Act, as I'm sure you're aware, the purpose is to ensure open and transparent government. And it requires meetings of governmental bodies, such as this board, to be open to the public and preceded by public notice of the time, place, and subject matter of the meeting. And the statute contains a provision stating that the provisions of the Act are mandatory and should be liberally construed in favor of open government, meaning if there's a question about the applicability of a certain statute, it should be construed in a manner that favors transparency. And we'll cover 4 key concepts to help you better understand the Open Meetings Act. The first is a quorum, which is simply a majority of the members of the advisory board. In this case, the ACR board has a little bit of an interesting quirk in that you have 9 voting members, but it's 11 total members. You have 2 non-voting members, which would be our executive director and the chief of the ACR program, which is Bill Weatherly. But you have 9 voting members. So the quorum for any action is 6, but we prefer that if you're taking an action, an official action, we have at least 5 voting members present. And if a quorum is not present, you can certainly have your meeting, but you can't take any official action. You can merely not object. We've had that happen before, but you can't take an official action. Another key concept is deliberation. Easier word for that is discussion, and that is simply a verbal exchange regarding regarding board business. So the matters of air conditioning contractors and licensing and regulation. A meeting occurs anytime a quorum of your body engages in deliberation regarding public business. And I'll give a little example. If all of the members of the board today met in the break room after this meeting to talk about Dave Gonzalez's birthday party, that's not a meeting because you're not discussing official business. However, if you start talking about the licensure requirements for certified technicians, magically you have a meeting, and that needs to be preceded by public notice, and so you'd be in violation of the Open Meetings Act. Notice requires advance written notice of the date, time, place, and subject of each meeting held, and so you've got your agenda before you, which is actually filed with the Secretary of State at least 7 days before each advisory board meeting. And it's posted online both by our agency and by the Secretary of State. And one note, we are not free to discuss matters that aren't noticed in the agenda. There's a little bit of leeway on that on some administrative matters, but generally we won't break from the agenda. And as I discussed a few minutes ago, there are some situations where you could have a quorum of members where it might be kind of in a gray area. And so we'd like to discuss this. Well, what about social functions? What about conventions? What about workshops? Do your discussions there constitute a meeting that would need to be, publicly noticed? And the answer is, well, the question is, can you meet in an informal setting without violating the Open Meetings Act? And the answer is yes. If you are at such an event, convention, or workshop, you're free to engage in conversation that's incidental to that event. But if you have a quorum of members, let's just say you're at an industry meeting and there's a round table and you're talking about the regulation of air conditioning contractors, you definitely do not want to be sitting on that round table where there's a quorum of your board present, unless that is somehow preceded by public notice, because you'd be potentially in violation of the Open Meetings Act. Just some key points to remember. Always keep your guard up to some extent. Notice when you are around a quorum of advisory board members and act accordingly. If you're in an informal setting where a quorum of members is present, don't speak about board business. Wait until you are in wait until you have a group that is less than a quorum, or wait until you're in a publicly noticed meeting such as today. And also beware the walking quorum, which is an interesting concept you've heard us talk about before. A walking quorum happens whenever you have a number of members less than a quorum that has their own discussion and then communicates that discussion to other members of the board. So, for example, let's say we have a work group put together for your advisory board. We'll say 4 members. And a couple of the members talk about the work group discussions to other members. All of a sudden, you've got 6 or 7 people effectively engaging in that work group. And so that's in violation of the Open Meetings Act. And so when we do appoint work groups, we ask you to discuss the subject matter of the work group only with that group, and wait until you come to a full meeting of the advisory board to issue your report. And so here's some good practices to avoid a walking quorum. If you do meet in small groups, don't communicate the subject matter of those discussions to other members. And if you're going to email, even if you email people individually, just be wary of that. You don't want to reach more than a quorum. Social media can be a little problematic. Let's say you make a Facebook post about a work group discussion, and all of a sudden you notice that 3 of your friends who are also on the advisory board comment, post some feedback under that discussion. You might accidentally create a public meeting in a Facebook comment thread. That could happen with Twitter, with retweets and things like that. And also, don't ask a quorum of members, even individually, for their vote on a particular issue. That's called polling, and it is frowned upon, to say the least. An interesting little wrinkle here is that the Texas Court of Criminal Appeals recently struck down a criminal provision of the Open Meetings Act as unconstitutionally vague. And that was the provision that dealt with walking quorums. Since then, all agencies in Texas have gotten a letter from Governor Abbott actually commanding us to adhere to the spirit of the Open Meetings Act, which we certainly do at TDLR. So I would still ask you to be very wary of the walking quorum, even if temporarily that criminal provision has no effect. And alluded to this earlier, this body is limited to discussing specific items on the agenda. Sometimes during public comments, a commenter might bring up a subject that is not on the agenda, and you're very limited in your ability to engage the commenter on that topic, unless it is somehow mentioned on the agenda later in the agenda. What we can always do is, if it's an intriguing, interesting issue, we can add that on the agenda for the next meeting. But we can't really engage with the commenter too much. But Ms. Winston will raise a flag, or I will, anytime things get too far afield. So the likelihood of this happening is not great in these meetings. There are some civil penalties for Open Meetings Act violations. Any interested person, including the media, can petition the courts to stop actions taken in violation of the Open Meetings Act. And an action taken in violation of the Open Meetings Act is voidable. And there are some misdemeanor criminal penalties for knowingly circumventing the Open Meetings Act. And in the PowerPoint, which I believe we can distribute to you, we've got some helpful links, particularly the Open Meetings Handbook put together by the Texas Office of the Attorney General. We'll just talk briefly about the Administrative Procedure Act, primarily rulemaking. So the purpose of the Administrative Procedure Act, we'll call it the APA, is to establish minimum standards of uniform practice and procedure for state agencies and to provide for public participation and comment and for transparency during the rulemaking process. Now, a rule, as I'm sure you're aware, is a statement made by an agency that implements, interprets, or prescribes law or policy, or describes the practice or procedure requirements of the agency. It also includes the amendment or repeal of a prior rule, and a rule is something that doesn't strictly relate to the internal management or organization of the agency. So TDLR's personnel charts or that's not a rule. That's merely a description of who reports to whom in the agency. And you'll see, probably during your service on the board, you'll see several different types of rulemaking occurring. Some are driven by legislative changes. For example, last session, when the new certified technician registration certification came into place, we engaged in rulemaking to implement that. You may see proposed rules from advisory board work groups or just advisory board discussions. Sometimes staff will initiate those efforts. Every 4 years, you'll be asked to review the ACR rules and make recommended modifications to those rules. There's also an interesting creature called the Rule Petition. Now, the Rule Petition, any interested person may submit a petition to an agency asking for the adoption of a rule. We have some TDLR rules that govern what those petitions look like. Essentially, what it boils down to is provide us with a proposed rule and the rationale for the rule. And any interested person is anyone who's a Texas resident or business entity located in Texas. Just a little run through of the rulemaking process. And this has changed just a little bit from what's in front of you. So you'll have the idea for the rule. Sometimes, let's just say that it's a staff-driven rule recommendation. We'll then internally draft and review. We'll make a draft rule, which we will then present to your advisory board for consideration, at which you'll comment, recommend changes. And once this body recommends publication of the rule, we will file the rule with the Texas Register. It gets published in that document, and it gives the public 30 days to submit comments on the proposed rule. After that comment period closes, the Office of General Counsel will review those comments, and if any changes are required to the proposed rule, we'll make those. We'll then bring the rule back to you for your formal recommendation to adopt. And what you're asking to do at that second stage is you're recommending that our commission adopt the rule. At which point our commission will review the rule filing, look at any comments proposed during the comment period, and either adopt the rule or not. If the rule is adopted, it'll be filed with the Texas Register and will be effective 20 days after filing. So you see this process can take a little while. And we have a new step generally before the rule will be sent to this body. We have to prepare a fiscal impact statement and submit that information to the governor's office. The governor's office has issued a letter to all state agencies asking to review any proposed rules. So before this body will actually see that, we'll have gone through the fiscal review process and the governor's review process. And then the rule review, like I said, every 4 years, we'll ask you to take a look at the ACR rules and determine if they're still necessary. By and large, they will be. But that also will give you another opportunity to maybe make some reorganizational changes, things like that. You can't really get too much into the substance, but it does give you an opportunity to reformat. So every 4 years, our office will file a notice of intent to review. The public will have 30 days to comment, and then we'll bring those comments to you as the advisory board. And excellent rulemaking resources, including some material put together by the Office of the Attorney General in the PowerPoint. And last, the Public Information Act, which you probably have heard referred to as the Open Records Act. And that's intended to allow every person to have information about the affairs of government and the official acts of public employees. And interestingly, this act makes all documents and other information relating to official business open to the public, with a few exceptions, attorney-client privilege probably being the one you're most familiar with. And I'd say most concerning to this board, I would think, would be that public information can include any electronic communication on any device that's related to your state business. So any communication that you have with TDLR staff or to each other regarding board business is potentially subject to an open records request by the public. So just keep that in mind. Just keep that in mind when you're communicating with staff, is that could potentially be disclosed to a member of the public. And again, as earlier spoken about, the act should be construed liberally in favor of granting requests for information. So do us a favor, if you get some kind of correspondence or even a phone call that looks like it might be an open records request, looks like it might be a request for information that you have on maybe a TDLR device, maybe an iPad, maybe you might get a request for some texts you've sent to another board member, please call the Office of General Counsel here at TDLR. Let us know about it, and we have a team that processes those open records requests. And we're really limited in the amount of time we have to request, or else we're in violation of the law. So we have to actually disclose those records or come up with an exception and ask the Attorney General for an opinion within 10 days. So time is really of the essence. So if you get something that you even think might be an open records request, please contact us immediately. And there are some exceptions to disclosure if there's sensitive information in those communications, date of birth, medical history, or comment on medical condition, something like that, that can be redacted. And again, we've got some links to some Open Records Act resources, and I just encourage you to in your spare time, to look over these resources, just to help familiarize yourself with rulemaking, with what's required of you as a board member. I think it's very helpful. And that's all I have. Any questions?
Board members, any questions?
Sure.
Thank you, Doug. Appreciate it.
Thank you.
I also want to make on the record, Mr. Morris has arrived, so we can move on to item D, approving the minutes from the March 5th, 2018 meeting. Do I have a motion to accept the minutes as written?
So move.
Second?
Second.
Please announce the name.
Richard Anderson, second.
First? Who was first?
Pat Kiley.
We have a first, we have a second. Everybody in favor, say aye.
Aye.
Anybody opposed? Motion carries. We move now to item E. Any public comment that we may have today? Public comments, none? All right, so let's go quickly into the staff reports.
Good morning, Chairman and board members. I'm Lisa Hodak, the licensing manager.
Good morning.
You have in front of you the licensing statistics with fiscal year 16, 17, 18, and then first quarter for fiscal year 19. And just want to point out a couple of things. As you can see, our registered technicians are continuing to, those numbers are continuing to climb. Last fiscal year, we had 7,200 new licenses issued, and first quarter this year, we're at almost 3,000 for registered techs. And on the second page, the certified technicians. So as you know, the new law went into effect September 1, 2018, which created a new requirement for the AC contractor. So the certified technicians wanted to get in at the last minute in August, and so a lot of people applied, and so we have new licenses issued for the first quarter of 2019 at 78, and those are for certified technicians. And usually people do that when there's a change in the law. They want to try to get in, because now the new requirement, they'd have to take the exam, and of course there's different requirements for that. So I just wanted to point that out to you. Do you have any questions on the licensing statistics?
Any questions from the board?
None.
None at all.
I would also like to mention that we have been working on, in regards to the new law, with the new contractor allowing certified technicians to come in a different way. So we've been working with that, and we'll be changing up the application. We meet on a monthly basis, and just as a team, and you may hear this from the other divisions, just making various changes, computer changes. We'll be changing the application, and this will be effective September 1, 2019. So we're getting prepared for that. And that's about all that I have. If you have any other questions or anything.
Any questions, board members? Thank you so much. Item number 2, Customer Service Division.
I'm going to give the, Mary Winston, TDLR, I'm going to give the customer service report today. We were discussing before this meeting how TDLR changes and grows and shifts, and with this session, which I'll discuss in a later report, just the different things that we do. Currently, our customer service division is moving from our downtown office to this building. And with that means moving not only office furniture and about 50 people, but an entire phone system. And so we saw them earlier, but they have some queues up there, and everybody's working to get that done. So they called yesterday, Trey did, the director, and asked if I could give their report. And so if we look at their report, it's basically giving you, they gave you the fiscal year of 2018, and the beginning of fiscal year 2019 through February. And the numbers, if you have any questions, I can definitely bring them back to our staff. But looks like in February, email totals were just under the call totals. So we still have a lot of calls coming in. And I know that statistically, this group also contacts or refers to our website via their laptop, not a mobile device. So we try to capture all ways of social media that you can catch us. So if you have any customer service questions, let me know. Lisa talked about some jumps in license types for various reasons, and I can get those back to customer service, and I'll get a response for you.
Members, any questions?
No, sir.
No.
When does the Dolores Compion, when do we expect that transition to take full place?
The full transition will the final switch on. We're working, and the reason we can't move everything at one time is because we're still working. So for this next holiday weekend, when everything's closed down, then that'll be the light switch turned on, and everything will be at North Campus for customer service.
Thank you. We move on to item number 3, the Enforcement Division.
Good morning, Chairman, board members. My
Good
name is
morning.
John Medlock, Senior Prosecutor with the Enforcement Division. As you can see, we've kind of got a large report because we haven't met in the last year, so we'll kind of go through it as if you got any questions, feel free to stop me at any time and ask those questions. As far as current projects, this will be something that we'll talk about here in a little bit, and I'll be presenting it. It's the enforcement penalty matrix. It was an update to that. We had some different law changes and some different things that we did with it, and I'll go into that in further detail. But the advisory board members that were a member of that was Mr. Compion, Mr. Holsey, Mr. Bittner, and Mr. Weatherly, who is now our chief AC expert here with the department. But again, that'll come up here in a little bit later agenda, and we'll go through that fully. As you can see, we were really busy, the staff was, with meetings with the Texas Air Conditioning Contractors Association. We had 4 different meetings over the last year. Our lead investigator in Houston and Harrigan Demos met with them in April. And she talked about basically what the enforcement division does, how we use our undercover stings to catch unlicensed AC contractors and electrical contractors, or people posing as that to do those kinds of work in those different trades. In September, another investigator, Tony Gattaca, met with down in Houston with the Texas Air Conditioning Contractors Association and discussed the different procedures that are going in for the new certified technician certification that came on board in that September 1 timeframe. I attended a meeting down in South Texas along with Bill Weatherly to kind of go over some of the what the enforcement division does, and Mr. Weatherly kind of gave some his perspective of how he was going to be approaching his role here at TDLR, transitioning from the public sector, the private sector into the public sector, and kind of gave some tips to the contractors down there, like in case you had issues, this is what I would do, and gave out his contact information. And then finally, recently, Ms. Demos met again with the Houston area TACA to talk again about some more undercover sting activities and some more enforcement stuff that we've been doing. We also had a couple, Mr. Robert Nino, one of our investigators in San Antonio, met with the Refrigeration Service Engineer Society on a couple of different times. Had a couple of chances to talk to some students about the changes to the certified technician rule that came on board in September, and just some different enforcement requirements and some of the processes that we have here. We also had a chance, some of our investigators had a chance to speak at some different continuing educations that different contractors had provided over the last year. As you can see, Mr. Gattaca attended a class at Johnson AC House in Houston, spoke to approximately, I believe it was, attendees there to communicate the different agency goals. And it was also, I think, simulcast down in the city of Alamo. Robert Nino spoke to Johnson Supply in San Antonio, and then Samuel Lynch spoke with a continuing education class with the coastal HVAC in Houston there. Again, we've had a lot of our investigators busy over the last year, and different staff members attending different meetings. So if you guys haven't one, feel free to let us know. We're happy to provide that. Regarding the case highlights, we have 5 different cases that I'll highlight today. The first one is Alfred Camacho. This resulted in an agreed order that was signed August in 2018. He is an air conditioning contractor, and when he installed a new air conditioning unit in El Paso, he failed to install the ductwork in accordance with the ACA Manual D, and then he also installed a return air vent that was too small for the system. This resulted in a $3,000 penalty, in which Mr. Camacho did pay, and we also assessed an additional 8 hours of continuing education in that agreed order. To date, that fine has been paid, and the CE has gone through, so he's completed everything that was required of him for that agreed order. Second case is Russell Yates. This was a default order. He is a licensed air conditioning contractor. He installed a new furnace and evaporator coil in College Station. He failed to pull a permit prior to performing that installation, and there were also 8 additional violations of the 2012 IRC code, which was adopted by College Station. The violations range from not including sediment traps as required, failing to seal refrigerant lines properly, not sealing ductwork properly. He was assessed a $9,000 fine and a 1-year probated suspension. He did not respond to the notice of violation, which is why it resulted in a default order. Typically, when a default order goes through, we don't really have a whole lot of hopes of collecting it, because most of the times the default orders go through on the people who are unlicensed, and so they're a little bit harder to catch. In this case, it was a licensed contractor, and he just didn't respond. Typically what happens is we'll put an enforcement hold on that, and then usually when they go to renew it, they have to make payment on that. And in this case, he actually did get in contact with the department and did pay the full $9,000. The third case is Maria Villatoro. This is resulting of 4 different cases in which she had with the department, and a default order that was signed in June of 2018. She had $32,000 of administrative penalties assessed against her, and her license was sought to be revoked in this alleged violation letter. She failed to respond, so it went to a default order. Her violations consisted of failing to install air conditioning systems according to the manufacturer's installation instructions, and also the relevant codes in the different municipalities in which she was performing work. Again, like I said, she didn't respond to any of our notice letters, and as a result, the default order for $32,000 went into effect, and the revocation. Again, I checked this morning, no payment has been made, but her license was revoked. The last two cases are a little bit different. They're criminal history cases. So not only do we deal with consumer complaints or complaints from the industry, but we also have criminal history cases. Everyone that has a license or seeks to get a license with the department has to fill out a criminal history application. We review that, and there are certain guideline crimes for the AC industry in general that if you commit one of these, we're probably either going to deny your application, or if you've committed it while you've had your license, we're going to probably seek to revoke that license. That's kind of what the result of these next two cases are. Gregory Thomas, his case resulted in a default order signed in April of 2018. Mr. Thomas was originally issued an air conditioning technician license in March of 2012. He applied to renew that license on September of 2017. Prior to his renewal, he was placed on a deferred adjudication for two separate instances, one for violation of a protective order and one for another crime, aggravated assault causing serious bodily injury, both resulting from the same 2017 incident. The assault crime is one that is directly related to the industry, and as a result, the prosecutor sent out a notice to revoke that license. He did not respond to it, and so we issued a default order revoking that license. Typically, when these letters get sent out, just like in an administrative penalty case, they have the opportunity to ask for a hearing, go before the State Office of Administrative Hearings, and then eventually before the commission to determine whether or not that license will be revoked or that application will be denied. In this case, he just did not respond, so we just went ahead and revoked that license. And the last case is Joel Garcia. His resulted in his license being revoked by an operation of law. He was issued his registered technician license in June of 2013, and then on July of 2018, he sought to renew that license, but during the review of that criminal history, it was discovered that his that he had actually been incarcerated, and as a result of that, his license was revoked by operational law pursuant to Occupations Code 53021B, which provides that a license holder's license shall be revoked on the license holder's imprisonment following a felony conviction, a felony community supervision revocation, revocation of parole, or revocation of a mandatory supervision. So due to that imprisonment, his license was automatically revoked the day he entered into prison. And so once we find that out, we go ahead and issue that letter saying your license has been revoked at that point. And then he'll, depending on how long his incarceration is or when he gets released, if it's still within that revocation time period, he'll have to wait till that's over to try to renew, or he can just try to renew if it comes out later. And lastly, statistics, as you'll see, these go through the end of January. We're basically running at about a 10% of what the agency total is for the air conditioning program on cases open, cases closed, essentially the penalties assessed and collected. That's about the norm for this program. Is we're about a 10, we maintain about 10% of not only just cases open and the volume that we deal with, but also cases closed and the penalties assessed. So we're kind of right on track for where we normally are at this time of year. So if you guys have any questions, I'll be happy to answer them.
Board members, any questions?
Yes, Jerry Bittner.
Yes, sir.
With respect to Camacho case and the Yates case, did both of those occur as an initial result of complaints by the customer?
Yes, those were both consumer complaints.
Okay. And this Maria Villatoro, what was the geographic area in which this violation was encountered?
I'm not 100% sure on that. I can go back and double check and let you know, but I want to believe it was in the San Antonio area. But I'll double check and get back with you on that.
Okay, thank you.
Dolores Compion, I have a couple of questions. One of them is on the statistics.
Yes.
Kind of spoiled us a little bit. Could you add the percentages on there,
Yes.
on the matrix? If you would, please. Humble request there. And secondary question was, how was the meetings received with Mr. Nino and those, with the announcement of certified technician programs or the programs we had initiated?
I do not know because I have not spoken with him about that, but I can get that information to you.
A little short recap on, you know, the temperature of the
Yeah, we'll
of the
make sure we
industry
get that to you.
All right. It's, any other questions?
Richard Anderson, I have a couple follow-up questions also. Last year, I asked for some statistical data in this same report based on the number of complaints that were resolved with the contractor and citizens. That
Okay.
did not go to either an agreed order or something like that. 'Cause I
Like
know you-
something that was like either like informally resolved because there was a consumer refund or
Right,
something along those
right.
natures.
We kind of asked for that data as well,
Yep.
because it shows that our contractors are out there doing good as well. My other question goes to revocation.
Mm-hmm.
And how do some of the smaller municipalities that don't have things in play to check licenses on a regular basis and perform some sort of registration process, even if it's just somebody coming in and saying, yep, this
Right.
is my license? Does TDLR inform the built community as the municipalities to revocation automatically? Is there something that those municipalities can do to sign up to make them aware of somebody that could be operating in their municipalities that their license has been revoked?
We do have a listserv, and obviously our public website has, if somebody has been revoked, and all of our orders, so all these orders that you've seen here are listed on our website, and they will be listed as what the, basically a recap, a summary of what it was the violations were, a little bit more detail than what I gave, and then also what the subsequent penalty was, including revocation. And then again, you can always double check license status by, there is a license search feature on the website. Again, there's a listserv as well for information, and I believe our website is trying to promote some like bad actors page, so that there's really good information on that. We try to do as much as we can through our RPM division for community outreach to let them know, hey, if you've got issues or questions, get in contact with either RPM or the enforcement division. We work really well together, and so anytime that there are issues, we try to get either the consumers to file that complaint or even the building officials to get us that information so that we can maybe file our own complaint if we need to.
Thank you.
Board members, any other questions? Thank you, Mr. Manley.
Thank you.
Moving on to item number 4, Education and Examination Division.
Chairman, members, good morning.
Morning.
I'm Fanny Pringle with Education Examination Division. I believe you have our report in front of you. I'd like to start with the continuing education statistics. We have the last 3 fiscal years listed for statistics, and one thing that has not been included that I'd like to note is that to date, no one has applied to be a certified technician training program provider. That program's been in place since September 2018, but no one has applied to be a training provider yet. For the examination statistics, I believe everyone got the revised numbers. We had some problems with the embedded formulas, and so the numbers were off, but everyone, I believe, got a corrected copy. And everything is on track with the previous fiscal year and previous quarter. Everything's pass rates and number of testers seems to be consistent for this time of year. And for news otherwise, we have an upcoming examination review committee meeting on April 4th and 5th of this year. This meeting is going to be planned to go over poorly performing items as well as overachieving items. And there may be some discussion evaluating another duck size calculator to be used for examinations. Our regulatory program management has already reviewed the new calculator, but we'd like to have the ERC group evaluate it and have it approved for admittance into the examination room as well. Are there any questions?
Dolores Compion, it appears that in December, it just kind of had a bad month, huh?
Let's see.
Out of the 12 applicants, 5 of them failed. Did I read that correctly?
Let me look at my numbers here. December, you may be looking at, let's see.
Examination stats, am I reading that correctly?
That's the original, you're looking at the screen. I provided everybody with the updated numbers, and that's where there was some embedded formula problems that weren't capturing all the information. So where it was previously, I think you said 12 for December?
132.
Yes, 132 is the corrected number.
February had 170. Any trend that we see?
Nothing, nothing significant. That it seems to be consistent with previous years, previous quarters. We have, it's grown by a few testers from the first to second quarter. Does seem to be, it does seem to be pretty consistent.
Thank you.
You're welcome.
Board members, any questions?
No.
Thank you so much.
Sure.
Item number 5.
Well, good morning, Mr. Chairman and board members. Glad to be here.
Good morning.
I am Bill Weatherly. I'm the Air Conditioning and Refrigeration Program Chief. I've been here 8 months. I was formerly a member of your party up there, and it's been an interesting 8 months. I'd like to kind of start with introductions to some newer members that are on our staff as well. I have an assistant, Jeff Nielsen, who's in the back. Raise your hand, Jeff.
Welcome, Mr. Neal.
Jeff is a program specialist and my assistant, and very, very competent individual, has been in the air conditioning business for many years, as well as I have. Also, I'd like to introduce the mechanical section manager, Yvonne Feinlab. She is also my immediate supervisor.
Welcome aboard, ma'am.
Okay. And just to give you a little rundown of what we've been up to here lately, Jeff and I have conducted some field complaint investigations in El Paso, Houston, and Uvalde over these few months. And when we do that, we work in conjunction with the enforcement group. And as you may know, the complaints come in to our intake and enforcement group, and they sometimes they can take care of those complaints themselves if it's unlicensed activity, that kind of thing. When there's mechanical integrity, then that's when we get involved and help them. And sometimes it's on the front end, and then sometimes it's on the back end when it goes to the prosecutor, if it goes that far. But we conducted field investigations, and the idea is a consumer has a complaint, and then the best thing that can happen there is that we can talk to the respondent, who would be the air conditioning contractor, and resolve some of those issues that are legitimate issues. And sometimes they're not always legitimate. We'll find that out too. But resolve those before it goes any further, I think that's the best thing that we can do for the citizens of Texas. But being a subject matter expert, and that's kind of our role that way. Also, I think John Medlock, one of our prosecutors, mentioned that back in October, we actually conducted a sting in the valley. Actually, in the town of Alamo, there was one of the larger air conditioning contractors down there, Mr. Hess. He was complaining about unlicensed activity, and as well as some of the other contractors. And so Mr. Hess owned a bank building that was vacant at the time. So this is put together by the enforcement division, and they do a wonderful job at it. It just works like clockwork. But came down and set up shop, and there are a couple of air conditioning units, and so they went through, Green Sheet, Craigslist, things like that, and looked for advertisements where there was no license number on the advertisement, which is a violation in itself. And during this process, made the calls. There were about, I think, 4 or 5 enforcement folks there that had done this before, and asked them to come out and give basically a proposal, you know, to repair and replace these air conditioning systems. And it was interesting. Some of them gave it to us on a napkin and asked to borrow paper. And, you know, it was interesting to me, being a contractor, that there was split systems. There was a condensing unit on the roof and then units inside. And no one went up onto the roof to look at the condenser, but they gave us a price anyway. So don't want to, you know, get too deep in this unless you have some questions. But then at the end of a couple of days, I think there were 40-something violations that they basically categorized, and we invited 3 of them back to basically get their money, or the contract or whatever, and working in conjunction with Channel 5 News down there. They'd done that for us before. They set up some GoPro cameras around, and we had the on-air newsman, investigative newsman there with his cameraman, and so when they came in, they got a little surprised, and they talked to the camera and the man, and then we made them famous basically on that. So I think there were about 40 cases that we did on that, and if you'd like to look at that, it's very interesting. If you go to Channel 5 News in McAllen and go in their on their website and look under investigative reporting, and you put in unlicensed contractors could be costly, you can see the video, you know, of that, which is very interesting. Also, the other part of my job duties is public outreach, and it's a part that I really like doing, and it's contacting the different groups and speaking. And one of the first ones I did was with John Medlock, who was up here before. We went to McAllen and went to the Valley, and we talked to a group down there at South Texas College, and it was very well received. Had about 30 contractors there, which was very nice to see, and also some students from the college. And then other places that we've gone, Jeff Nielsen and I went to Houston and talked to the Texas Air Conditioning Contractors Association down there. I've talked to them in Austin. Just recently, Jeff and I went to Amarillo, and we talked with the Panhandle Inspectors Association up there. They had some questions, and they were very welcoming to us. And boy, it's windy up there, I'll tell you, up in the plains up in Amarillo. But we had a good meeting up there, and that's I think also then sometime in the future, I think our public information officer wants to do some Facebook Live things, and I'll probably do some of those, just to, you know, one of them for the contractors and another maybe for the general public, something like that. I'm on a bill implementation team, and it's something that you all had worked on as well, the certified technician team. We're trying to get all the rules you know, lined out for that, and hope that the program will go. At this point, I think you heard from previous speaker that we don't have any programs yet put together for the certified technician program. However, it's available just through experience, and we've had some that have applied and taken the test with the new program. One of the things that we're involved in RPM is exam development, and that's happening April the 4th this year here in Austin, and that's where we get our subject matter experts together. We review the psychometrics of the exam, you know, take exam questions and look at how many folks actually missed that question. You know, we had a 10% you know, right answers on it, and then we look at that. Do we need to revise the question? Is the question good? That kind of thing. And we've got some really qualified folks that I'm going to meet here next couple of weeks to do that exam review, and that's done with PSI. And then we're looking to also publish a newsletter, the TDLR blast, that has to do with ACR. And I would ask any of you on the board that if you have any input or any ideas or questions for our newsletter to go out, that you contact me, and we'll definitely put those in there and try to, we always use good ideas for that. And then on a daily basis, some of the things that I do is answer lots of questions from customer service. They'll get ACR questions, and almost daily I get 2 or 3 that way, and you know, get to call and answer the questions and you know, help out that way. So that's pretty much all I've got. I'm glad to be here, and I'll answer any questions that you have. So.
Board members, any questions?
None.
Dolores Campion, I have a request.
Yes, sir.
How many sting operations will we do this year, 2019? Or do we have, I know there's budgetary constraints that go along with that. but-
Right. As far as I know, there haven't been any planned, but I don't actually do the planning. That happens in enforcement and then also from the feedback that we get from contractors and from the public. So I can find out, you know, about that. I don't know. Maybe Mr. Medlock knows or none.
Again, John Medlock, Senior Prosecutor for Enforcement. Typically, we do about 2 a year, and we don't try to hit the same areas. So again, in October, we just kind of hit the Valley area. So the next one may be in a different region, and it also kind of depends on need, where we're kind of seeing little hotspots of unlicensed activity, where we're getting a lot of advertising coming in, complaints, things of that nature. We don't currently have anything scheduled yet. We're still kind of collecting that data because we like to get a lot of leads before going down there and setting everything up, because if we're going to expend the resources, we want to make sure that we kind of make it worth our while at this point. But on average, about 2 a year is what we do.
Dolores Campion, another question. That percentage, I think we mentioned 40. A case gets open on those 40, and what percent type individual? So what percent of that is our total number for 2018, or this happened in 2019?
Let's see here. I'm trying to remember how many stings we did, but I think we did about 2 stings, so we probably opened about 80 cases, and we have about 1,200 or so cases. So it's pretty close to anywhere between a little bit less than 10% of all the cases that come in.
Can you add that to the stats?
We
just so
can-
we
we
can
can-
see it at a glance?
Yeah, we can definitely add sting stats to that.
Thank you. Thank you, Ms. Whitley. Thank you, Mr. Madlock.
Richard Anderson, I had a follow-up question. As far as the stings go, are you organizing that with partner departments within TDLR as well as other state agencies to get the most out of that, such as the electrical licensing program, maybe the board, so that everybody's kind of a one-stop?
Right.
Work together?
We definitely do it within the 2 programs of AC and ELC that we both house here at TDLR. I know invitations have gone out to Plumbing Board occasionally. I don't think those have been taken up yet at this time, so we have tried to coordinate that as a multi-agency thing. But at the same time, we definitely do electrical and AC at the same time, try to get as much as we can when we do those things.
Thank you.
No other questions? Thank you, Mr. Madlock, Mr. Whitley.
Well,
Appreciate
thank you
it.
very much.
Moving on to item number 6, the executive office.
Mary Winston, attorney. I'm going to be giving the executive office report today. I want to start off by saying that Bill, Mr. Weatherly, has been just a breath of fresh air, a great infusion into the TDLR bloodline. Yvonne Feinleib, we were able to snatch her from last legislative session when we were given other programs from DSHS. And she is just like a sieve. If you give her some information, I mean, it just goes down into that brain. She sucks it all in, and she loves it. She's always bouncing around, and I'm like, you're so happy, you make me happy. And having Mr. Weatherly coming in as the new in-office expert, fresh from the industry, real-world knowledge. So we have a lot of meetings here. We have a lot of meetings. And our executive director's like, get Bill, because we sit here in Austin or wherever we're sitting, we can read statistics, but someone to have a fresher perspective is always great. So I love the report. This profession is very engaged with almost 50,000, over 48,000 licensees. We have over 700 hits on the website a day. Last 6 months, 130 plus website views. So for those who are in the industry, have questions with the industry, they do know to reach out to TDLR, and we try to get, for instance, speaking, and that's what RPM does. Part of what RPM does is to get out there to the public and get this information out, and they've been doing it. So Executive Office Legislative Session Update. Well, are we midway? We're midway through the session, and there have been a lot of bills. Currently, our Strategic Communication Office, I think Jeff is behind that pole back there. Jeff Kopus heads the call of following the bills. The bills that TDLR are following are on the front page of our website, and it just says 86th legislative session. You click, and it'll give you the same rundown that we have. I just tapped Jeff on the shoulder this morning and said, how many bills we're following? 400. So that will go down as we figure out, because we really try to track all bills that could possibly touch our licensed body. And as we see that those don't touch the licensee body, or as those bills go by the wayside, Jeff then checks them off of the list, and we know not to follow them once he puts out his report once or twice a week. Currently, we have our executive director, as well as our deputy, as well as our director, Christina Kaiser, and myself are heading over after this to attend Senate hearings. But this morning, Brian Francis was giving testimony in the House, legislative appropriations, and administrative procedures, LAPSI, we always say LAPSI, into that committee. And we're moving forward. Let's see, currently, I was having both screens go at the same time, but I need to pay attention and not multitask so I can focus on one thing. I do believe that the testimony's been given there, but we'll be double booked often. And so when we're double booked, we have our executive director one place. He's going back and forth. We have our deputy, Carla James. We have our government relations staff running, and then I provide backup for that. So currently, there's one bill that does touch, that we're following, but I think it's 4249, but that has to do with fees charged by a municipality, but jury's still out on that one. There are no current updates today, but when we are done with this meeting, we'll head over there and we'll get more information as we can. And that's one reason that we're glad we're having this meeting today, because we have business to attend. But in speaking with our general counsel earlier, Doug Jennings, we do want to have a couple more meetings by the end of this calendar year. And then we can give you an update of everything that happened during session, and we can take care of any other business. And we also are well aware that we want to thank you, because we have some people who are expired for their board positions, and we're working on getting those advisory board positions filled. We do have a button on the web page. We are actively taking applications. I guess that's my plug. But if you go to the website, you'll see, anyone out there, that there are openings, and we would love to have some fresh blood into the advisory board as well. Any questions?
Well, we're definitely, Dolores Compion, we're definitely going to not ask for a recap on the 400 bills. Yeah.
No.
Right? So, we're
Jeff could give it, but.
But we're definitely going to utilize the time and talent of the new team, Mr. Weatherly and his team. So welcome aboard, and appreciate all the experience.
We've dragged him down there too. He's running around the Capitol with everybody. What is it? We drinking from the fire hose? Is that what we always say? So I'm glad you've been able to keep up, because our executive director is. He'll listen to this later. But what is it? ADD? You know, he's all over the place. So we all just try to keep up with him. And Bill's done a wonderful job.
Well, like I said, welcome aboard, and thank you so much. And we definitely utilize the time and talent. And we'll move on to item G. Discussion and possible recommendations regarding the penalty matrix for the air conditioning and refrigeration contractor board.
Good morning, Chairman and board members. Again, my name is John Medlock, Senior Prosecutor with the Enforcement Division. I'm going to be presenting to you today the penalty matrix, which came from the work group meeting. Again, like I said, it was Mr. Compion, Mr. Holsey, Mr. Billy Bittner, and Mr. Weatherly. But before I present it to you, let's just kind of talk a little bit about what the penalty matrix is. So what do we use it for? We publish it. It kind of puts the industry on notice. It's like if you happen to run afoul of the TDR laws and rules, this is kind of what you can expect from a notice letter if this is something that you're in violation of. It's also guidance for myself and the rest of the prosecutors on the ACR team as to what penalty we can seek for a particular violation, because we kind of strive for consistency across the different programs that we have and the different violations. It also is a formal enforcement action against the violator. So whatever the action is that, or the violation that has occurred, that is kind of what we're going to be seeking and what we're going to be doing. It can be a combination of a penalty or a penalty and some form of a sanction. But again, that penalty matrix lays all that stuff out. What the penalty matrix does not do, it does not create new law. And Chris is bringing it up here in a second for you guys to review. But as you can see, it'll have like subject headings and wording, kind of almost as like guidelines. It's like, hey, if you commit unlicensed activity, you can assume you're going to get this range of penalties. But it doesn't take place of what the actual law says. So when we cite you, there is a code cite or a rule cite or a statute cite that we actually use in the actual NOAV language. So the language that's contained in the enforcement is penalty matrix is for guidance only. It's not actually new law. It also doesn't obligate the department to actually impose a penalty if a violation is found. It only comes into play if the lawyer decides that using discretion to pursue some sort of formal action against the person. Because sometimes, and we'll talk about this here in a little bit about resources, but sometimes there may be reasons and rationales for not pursuing certain violations. It's also not binding on our commission. While it's binding on myself and the rest of the prosecutors as far as what we can charge, it's not binding on our commission. They have their own statutory authorities to what they can charge when a case, and usually the only cases that go before them are the ones that have come through a contested case process through the State Office of Administrative Hearings, and then they hear the back end of it, and then they can either recommend to adopt that proposal for decision or and modify it if they so choose. But again, the penalty matrix is not, they do adopt it and they do approve it, but they're not bound by it. So I think that that's kind of important. Again, like I said, this penalty matrix comes from the work group that was comprised. As I stated earlier, that was back in February of 2018 is when we had that meeting. We made two kind of substantial changes. One was we moved a lot of the insurance violations from a Class B to a Class C. We moved a Class B violation that was failure to register all the registered agents from municipalities with a municipality to a Class A. And then we moved a somebody using a certified technician designation to a Class B. Also, we added all the new certified technician language and violations in this penalty matrix. The second major change that we did is we've gone to a single range. In the past, we've had violations for first, second, and third with increasing penalty amounts, but we've eliminated that. And the reason we do that is for a few different reasons that I'll go into. Essentially, now it's whether a respondent has a first or a fifth violation, there's just going to be a single range, and there's broader discretion that the prosecutor has to be able to charge it accordingly. And also with the single range, it allows us to take the same violation from two different people that have essentially the same violation, but the circumstances may be a little bit different. That allows us to say, okay, maybe this contractor was committed some sort of mechanical integrity, but he tried to rectify it, but couldn't quite get it all the way corrected. So maybe this person needs a little bit lower penalty, but this contractor had the exact same mechanical integrity violation, but made no effort to correct it. So this person probably needs a higher penalty. So giving a single range allows us to have discretion within the different penalties to allow us to try to be as equitable as possible for the situation at hand. Because again, in programs like air conditioning, the bulk of our stuff is consumer complaints, and so we want to take acts to try to rectify the situation, or acts to not try to rectify the situation. We want to take that into consideration as well, because if we have a contractor that is trying to do right and trying to fix it but just can't for whatever reason get it accomplished, or maybe he and the consumer have just butted heads, but we can see that they're trying to do good, we want to take that in consideration versus someone who has just decided, you know what, I'm just not going to even try to address the situation. Also, it's a simpler approach, and it eliminates the progressive increased penalties from one case to the next. It's also a good thing because we've seen that respondents don't, once they've been fined once, they don't necessarily continue getting worse. They usually actually don't. I mean, the recidivism is not as much as what we would think it would be if we had the first, second, and third. So just eliminating that first, second, and third, and just sticking with a single range helps us in that regard. And then also this recommendation is based on our experiences working with our other legacy programs, that it's also been a stumbling block with us before the courts, because sometimes the courts wouldn't interpret the first, second, and third correctly, and they would allege it as a first when it was actually a second, or sometimes they would allege it as a second. Maybe it was a Class B in the first case, and the second case it was a Class C. And they would consider that, well, you only had one Class B, and now this is a Class C, so they're both first. So we found that that was always an issue that we had, trying to get over explaining to the different courts that we have to take our cases to that, no, this is a second, and here's why it's a second. So by eliminating that and just going to the single range, and that helps. Also, it goes along with our strategic plan, and if I think Chris wants to pull it up, if not, one of our strategic initiatives and goals that we have with the strategic planning process was to prioritize our enforcement efforts to resolve complaints involving consumer harm or threats to public safety. So if we're having a lot of record-keeping violations or violations of like minimal advertising, not like having your license on your invoice or a vehicle or things of that nature, that's not going to pose a direct harm to a consumer, and we want to take our limited resources and focus on the ones where somebody has gone to someone's house and completely messed up a system and affected a consumer directly. So we want to take our limited resources and focus them more on those types of cases than some of the other ones that we can handle in other matters. Because it helps just streamline our procedural steps to ensure that we get prompt investigations and to get resolve these complaints quicker and sooner. So when I walk you through this, I'm going to be asking you to approve this penalty matrix to go up to the commission for their final adoption, and we can kind of handle it one of two ways. I can walk you through what the changes were line by line, or if you've got direct questions on any of the changes, as you can see, they're redlined, and everything that's redlined has been taken away, and anything that's kind of blue and underlined are the new additions. So we can either do it, if you guys have specific questions, I can walk you through it, or if you want me, I can walk you line by line.
Dolores Compion, I don't have any specific questions as to the adoption, but should we ask any commentary at this point before we make a motion, or should it wait after? It doesn't reflect on the motion or the adoption.
It doesn't, Mary Winston, TDLR. It depends on the board. John's kind of laid out really great explanations of how enforcement tries to proceed. This documentation is in your packet, but if you have specific questions, you can ask. Either way is really fine. If you're comfortable, you can move forward. It depends on the members of the board. Now's the time for any discussion.
Pat Kiley, does the work group recommend approval?
I believe so. I believe this is the product of the changes that were recommended were mainly coming from the work group and the different violations that got moved to the different classifications.
Then I would move we approve this.
Then let's make Dolores Compion. Do we have a motion to approve?
Pat Kiley, I make a motion to approve.
Second?
Rob Standley. I make the second.
So we have a first and we have a second. All in agreement, say aye.
Aye.
Any opposed? Motion carries.
Thank you,
To
guys.
approve as written.
And just a little bit of information. So after this, it'll go before the commission. The next time we have a commission meeting, we just had one this previous Friday, so it'll probably be on that agenda. And then when they adopt it, it'll go into effect at that point. All right?
So, Dolores Campion, I do have a question. It wasn't regarding to this. It was more of, I think, the report that was given here, how it coincides with the report that was given earlier. And I think Mr. Anderson brought it up where how many, does every case get a number, and how many of those cases never saw the next level?
Yes, every complaint, everything that comes into our intake, it's either a complaint or a case. If it's a complaint, and let's say that the person doesn't give enough information to substantiate either who the respondent is that they're trying to say that violated the law and rule or some kind, or maybe they said that, yeah, this person came out there, but they didn't provide enough information for us to open it up into a case. Those don't get numbers. They get like an internal tracking number, but they don't get an actual like ACR 2017 or 2019, and right now, fiscal year 2019 case number. Once it goes to a case, it will go to an investigator. That investigator will contact the complainant, the respondent, gather, if there are other witnesses that they need to talk to, gather all that information and send it to myself or one of the other prosecutors. At that point in time, it's our decision based on the evidence that we had. Maybe we need to do some further investigation. Maybe we need to, contact a respondent because there may be some kind of willingness to make a refund or make the consumer whole. We'll definitely reach out to that regard. But there may be sometimes there's just not enough evidence, and so we either close it, or if it's a situation where they can quickly rectify it, like an advertising situation, maybe they forgot their number on an invoice or an advertisement or something like that, we can quickly close that with a warning. It's like, hey, make sure that, technically this is a violation of the advertising part of the rules. Make sure we'll get verification of that correction, and we'll close it with a warning. So, yes, every case every one that becomes a case does get a number, and it will result in either a closure, a warning, or some form of administrative action in the form of either a administrative penalty or a sanction.
Dolores Campion, if you could add some of those. I know that too many numbers can be awfully misleading and confusing, but I think the board would appreciate looking at things at a glance.
Yeah, we can
as
probably
to-
give a breakdown of in that case resolve number. We can probably, because that case resolve number includes warnings, closures,
Right.
defaults. We can probably break that down for you.
Kind of would maybe gauge how well our industry is actually really doing versus the doom and gloom of the other number, right?
Right.
And so I think we'd appreciate those particular numbers.
Absolutely.
So, yeah, thank you, Mr.
Right, thank you.
Appreciate it. We're going to power on. We'll be here and finished here in a few minutes. Move on to H. I'll make sure that I stay on track. H.
Thank you, Chairman, members. Again, Doug Jennings, Assistant General Counsel for the Department. Chairman Campion, I'd like to recommend appointment of a work group. Let me get a little bit into we can't have a full discussion, but let me give you some background information on why we're asking for a work group. As you're aware, an applicant for a contractor license is able to use certain educational achievement to substitute for the required experience. For example, an applicant for a contractor license can use certain four-year degrees, which are equivalent to 24 months of practical experience, count toward the 48 months required. Certain 2 years associate degrees are equivalent to 12 months of practical experience. It also allows an applicant for a contractor to use experience gained in a DOL apprenticeship program to count toward the practical experience requirements. One of the interesting things about the new certified technician certification is that there are two paths to that certification. One is graduating from a certification training program, and the other is accumulating 24 months of practical experience. Now, there's no provision in the recent legislation stating that an applicant for a certified technician certification can use these same educational achievements as a substitute for experience. The statute states very clearly that only applicants for a contractor license can use what's written in the law currently. And so we'd like to ask you, Chairman, to implement a work group to have a discussion about whether applicants for a certified technician certification should be able to use educational achievement toward their experience requirements, and whether any rulemaking would be necessary to implement that. And I'm happy to answer any questions to the limited extent that I can.
Dolores Compion, I don't have any questions. I don't know if any of the other board members, but I would definitely like to volunteer for that work group. I would need two other members.
I'd like to.
David Morris, I'd like to volunteer for that as well.
So we have David Morris and
Rob Stanley, and I'd like to also.
so work group completed. And we're probably going to reach out to Mr. Weatherly as well. So
Yes, Mr. Compion, we'll coordinate those work group meetings. I anticipate one, maybe two meetings between this board meeting and the next. If anyone happens to be in town, you can certainly come to our office for that. Otherwise, we'll just conduct it via teleconference, and we'll provide you the number and the information well in advance. And we will have staff, Mr. Weatherly, and I at least will be on the call, and perhaps others from staff.
for now, we are, thank you, Mr.
Thank you.
Jennings. Appreciate that. And
Mr.
Item-
Chair, was there a part two to that work group
we
discussion?
yes, part two, we're going to table that
Oh, all
for
right.
the time being until the next meeting. So we're tabling item number 2. That was, just to read it out loud, put it on the record, technical standards and rules work group to review, discuss, and possibly make recommendations regarding the definition of parentheses, or not actually parentheses, my apologies, total replacement of a system in 16 TAC 75.10. So we're going to table that for the time being and until our next meeting, which is segue into item I, recommendations for agenda items for the next board meeting, which I think we already have one already, right? Which is number 2, and item H. Any other recommendations for a meeting? Agenda items from the board?
Mr. Chair, Richard Anderson, I'd like to see if enforcement can come back with the data we requested.
All right, we'll put that on the agenda as well for the next meeting. Possible? So at this time, I wanted, first of all, Dolores Compion, up until about yesterday, we were trying to figure all this out, whether we were going to have a meeting today. So look, I want to thank all the staff members here at the TDLR, all the folks behind the scenes that make this happen for us to be here, and we get to be a little clumsy here, make some noise on the mics and things of that nature. And so we want to thank everybody for putting this together for us so we could sit here and attempt to betterment of the industry as a whole. And so, like I said, I want to appreciate all the staff members here today. I also have been informed that, kind of a little sentimental here, this is Mr. Kiley's last meeting with us. And so I want to take the opportunity to thank him for all the work groups that he's attended over the years and the many years of service that he provided to this industry as a member of this board. And so, I'd like to give a warm round of applause at this time.
Pat Kiley, may I just make a comment? First of all, it's been a privilege to serve, particularly with the high level and diligent board members I've seen over these 8.5 years. And I would also like to thank this extremely competent staff for the support we all get. So thank you.
So with that said, I think we already covered I. Let's go to J. Any discussion on the date and time and location of the next meeting? I think we were looking at
We're looking at Mary Winston, the summer, after session. We're gonna poll everyone. Session will end at the end of May, and June, July, the summer, but we will definitely poll the board in time. In the meantime, we have our work to do to get some more help. for some more membership on the board. We do appreciate you so much, Mr. Kiley, but every good thing must come to an end, so. So is that okay if we just get staff, if Delia can just contact the board members individually and pick 3 dates sometime, probably in July?
Absolutely. Dolores Compion, absolutely, yes. We'll leave that for June or July. And by that time, we should have some different representation, or the same, however that works out. So once again, I want to thank everybody here for coming today and taking the time to be here. And at this time, if there's no other questions from any of the board members, we call this meeting adjourned.